The visa that we're going to be discussing today is the spousal visa, and under the immigration rules, this is referred to as Appendix FM. So in order to apply for this visa, you will need to be coming to the UK to live with a family member on a permanent basis. And there's different types of relationships that qualify for this visa category, and they include a spouse, so that is the most common and the main kind of route for this visa type. You can also be a fiance, a proposed partner, a proposed civil partner. You don't have to be married, you kind of just lived together for 2 years as well, which we'll come on to on the next few slides. Children can also apply for this category, as can parents and dependent relatives. However, the requirements for parents and dependent relatives are extremely high, so that would be quite rare circumstances in which that would be permitted. Most people will apply for this visa initially from outside of the UK, and then once you're in the UK, you can extend the visa. You can also switch to this visa from other visas, and we will discuss that later on in the slides as well. In order to apply for this category, the family member that you are joining in the UK must be British or Irish, or they must have settled status in the UK. So if they have indefinite leave to remain, they would also qualify. This visa category is for people who are non-European nationals, and there are other circumstances in which you can apply for a family visa, for example, if your family member has refugee status. The waiting times for this visa are quite long, so if you apply outside of the UK, it can take up to 24 weeks to receive the decision. And you can't apply for this visa if your family member is in the UK temporarily. So, for example, if they're here on a work visa or if they're a student, they must be here on a permanent basis, either due to their British citizenship, Irish citizenship, or the fact that they have indefinite leave to remain. So the main requirements of this category are that you and your partner, so the person that you're coming to the UK to join, need to be 18 or over. And you need to be able to prove one of the following. So you're either in a civil partnership or married, and the marriage must be recognised in the UK. If you've been living together in a relationship akin to marriage, so if you've been cohabiting for at least 2 years when you apply, you may also qualify, but you would need to include a lot of cohabitation evidence to prove that you have been living together continuously. And if you are a fiance or proposed civil partner, so you're engaged and you have plans to marry within 6 months of arriving in the UK, you can also apply. In terms of the general requirements, you've got to show that you have the required level of English language, and this can be passed in a number of different ways. So either if you are a citizen of a majority English-speaking country, for example, if you hold a US passport, or if you have a degree that was taught in English, so it may not necessarily have been taught inside the UK, but it may have been taught overseas in English, then that would also count. Or you're able to take an English test outside of the UK, or perhaps you did have a degree that was taught in English inside the UK and then you left the UK, and that would also count. The income requirement is 18,600 per year. So when you are inside the UK, you and your partner must have a combined income of at least that amount. It can just be one income as well, so only one of you has to be working. It doesn't have to be combined. And there's also relationship evidence that's required, such as joint bank statements or tenancy agreements. When you arrive in the UK, you must intend to live with your partner permanently, so you must intend to live in the same house. And if you are applying as a fiance, you must be able to show that any previous marriages have ended. So this is evidenced by providing the divorce certificate, and you also must be able to show that you have plans to marry or become civil partners within 6 months of arriving. You and your partner both need to be over the age of 18, and you must be in a civil partnership or marriage that's recognised in the UK, and this is usually evidenced by a valid marriage certificate. And it doesn't matter if your marriage certificate isn't English, because that can be translated in order to be used as evidence. If you're not married, but you are in a relationship akin to marriage, you've got to be able to show that you've been living together for at least 2 years when you apply. And that evidence usually includes documents such as bank statements, utility bills, showing that you have the same address. If you are relying on this element, then you've got to have at least 6 pieces of evidence, and that would be 3 pieces per year in joint names. So, for example, you might have a bank statement, a utility bill, and a phone bill that shows that you have the same address and it's addressed to you jointly. If you don't have any joint bills, that's also fine, but you've got to be able to show 3 pieces each per year. So that would be 3 pieces of evidence addressed to you per year, and the same for your partner as well. And as we said previously, if you are a fiancé, you've got to have intention to marry within 6 months of arriving in the UK. When you are here, you've got to intend to live together permanently. And again, you've got to be able to show that if you have been married previously, that your marriage has ended and you have to have had a divorce. And that's it from me, thank you. Now moving on to the accommodation requirement.
Brilliant, thank you so much, Lauren. And before we skip from this slide, I'll just add just a couple of points, if I may, to the details that Lauren's already included. Showing that previous marriages or civil relationships have ended. Just to reiterate there, it's really important that the relevant family court documentation is provided. So where a marriage was previously within the UK system, you would need the decree absolute from the family court, and the plan to marry or become civil partners within 6 months of arriving in the UK for those applying under the fiancé element. The Home Office do want to see quite concrete evidence of that. You don't have to completely have finalised absolutely everything, but something like a booking in the registrar office, plans for a reception, that kind of thing, that it's sort of painting the picture to show that this is a real commitment to getting married. That's the sort of evidence they're looking for there.
So the main thing that the Home Office are looking for when it comes to accommodation is that you as a family have adequate accommodation to comfortably settle everyone. So that would include you and your partner who's coming to join you, and it would also include any family members that would also be living in the property. So that could be parents or siblings that would also be there. And you must also be able to do this without recourse to public funds. So that can include child benefits or housing benefits or universal credit, things of that nature. And it's important to note that the family must own or occupy exclusively the property. So if there are other families staying in that place and you're just renting a room within a larger property, then that wouldn't be deemed acceptable. So accommodation will be regarded adequate if it is not overcrowded, so there's enough bedrooms for everyone to settle there comfortably, and it must convene with public health regulations as well. So what can you submit to evidence that you meet this requirement? So the main thing the Home Office are looking for here would be land registry or tenancy agreements that show the size of the property and the named residents that are listed on the tenancy agreement or the other document they provide. So if for whatever reason your partner who's coming to live with you is not currently named on the lease, which would be the case in a lot of situations, where obviously you may have signed a lease for a property, and then a few years later your partner's coming to live with you, then a letter from the agency or landlord to give that permission for your partner to join you in future can be submitted as well. If you're initially staying in temporary accommodation, so if your partner is coming to live with you initially with your parents or with other family members, then a letter from the main person in the household to say that they're happy for your partner to come and live with you for a short time while you will set up a more permanent home is also can be submitted as useful evidence. So there are a few different ways that you can meet the English language requirement. The first is to be a national of a majority English-speaking country. So these are countries like the US, Australia, Canada. There are a few different Caribbean nations as well, where English is the main spoken language, is the national language, and so you don't need to provide anything other than a passport in that circumstance. You can have passed an English language test, provider in speaking and listening at a minimum of A1 level. I'll talk more on that later, but the A1 level is the lowest level for the test. It's to show that you have a basic to advanced level of English, but you don't need to be fully fluent in the language. You just have to have a good understanding of English, and the test would evidence that. You can have an academic qualification that was taught in English, so that would be a bachelor's degree or higher. So if it was taught in the UK, then you would just need to supply the degree certificate. If it was taught in a different country entirely in English, then you would submit the degree certificate along with a UK ECTIS, ECCTIS certificate, and I'll talk about that again in a little bit. And that would prove the level of English as well as the academic level as well. There are exemptions that apply for people over 65, or if you've got a disability that would mean that for whatever reason you're unable to take an English language test or something like that. So the academic test qualification, so if you've got a degree at bachelor level or higher, just still back to the previous one, Gemma, thank you. So if you've got a degree that was taught in English outside of the UK, then you can apply for what's called a UK ECTIS certificate. It's had previous names in the past, so you might see it listed as UK NARIC, NARIC, or UK ENIC, ENIC, but they all mean the same thing. It's just gone through a couple of name changes. So if you've got a degree that was taught, let's say in Egypt or in India, it was entirely taught in English, then you can apply for this certificate to show that it meets the required academic level. And so you would use that link here for the Visa and Nationality Service. You will need to sign up on their website, and once you've registered with them, you'll be able to send them your documents. Normally, in able to provide the verification, they would need a copy of your degree certificate or diploma, your full academic transcript or mark sheet, as well as a medium of instruction letter from your course provider that would confirm that the full course was indeed taught in English. One, please. And just a bit on the English language test, because there are quite a few different providers that offer the English language test, so this can be a little confusing. But any of these providers listed here, you can use to take the English language test. And like I have said before, as long as it is A1 level, then it would be approved for a spousal visa application. It's important to note that the test results are valid for 2 years. So if you've taken a test for whatever reason in the past, then that can be used later on. And once you've passed the test the first time, so if you're taking the test for your initial application from overseas, you won't need to keep taking tests when you extend or apply for indefinite leave to remain later on. You can rely on the initial test that you've taken.
Somebody was asking if you have a job with an English-speaking organisation, is that enough for the language requirement? I mean, any sensible person would think that it was, but unfortunately the UK authorities are very, very strict about how you meet the English language requirement. And years of experience, having worked with English speaking organisations in the past and planning to do so again in the future, I'm afraid they will not accept that. It's not one of the methods as what was set out by my colleague that would meet their requirements. So previous experience with an English speaking company, etc. I'm afraid that would not suffice for the English language requirement. You must either be the national of an majority English speaking country, have taken the test, or have a degree or similar qualification. Thank you very much. I'll hand over to my colleague talking to the salary, the income requirement. Thank you.
I would just like to take you now through the financial requirement for this application. So all applicants must meet a financial requirement in the form of an income requirement. So this means that you have to evidence funds of £18,600 to satisfy this. And as you can see on screen, for the first additional child, it's an additional £3,800, and then for every additional child after that is £2,400 to satisfy this requirement. If the minimum income requirement cannot be met, for example, if you have employment, the 18,600 cannot be satisfied, you can use cash savings above 16,000 in combination with this to satisfy the requirement. We've listed some situations where cash savings cannot be. So, for example, as you can see, the self-employment, income from employment as a director, and gross income received for 12-month period where a person has been employed with current employer. If we could just move over to the next slide, where we'll explore this requirement in further detail.
Income can come from a variety of sources, and we've set those out here. Most sort of straightforward is the salaried or non-salaried income of the partner. That's the person in the UK who the applicant is joining. Part B is non-employment income, and the kind of thing that we typically see in that instance is income from property rental or dividends from shares. So in the event that somebody has a prolific share portfolio and they draw a dividend from particular companies, that's the kind of thing that can be borne in mind here. Separately, state or occupational or private pensions. So where the applicant or their partner has a particularly lucrative pension and it is of pensionable age, then that's an alternative requirement. And that's basically acknowledging the fact that where somebody is at a pensionable age, most likely they will not be in full or even part-time employment. So it's an alternative presentation to them specific to their demographic. Part D is income from self-employment, again of the partner, so that's the individual in the UK who is being joined. Income from self-employment is absolutely something on which you can rely. It's just important to be aware that when it comes to the mandatory evidence, that really is very multifaceted. So the kind of documents the Home Office want to see really are very involved, and it even varies dependent on whether somebody is self-employed in a sole trader capacity or as the director of a company, then the specific mandatory documents will vary. So I would just say self-employment absolutely can be relied upon. It just becomes rather nuanced in terms of the evidence that needs to be provided. And then cash savings of the partner or the applicant can be borne in mind. They have to be held at a consistent level for at least 6 months. And when we say under their control, we mean typically in a bank statement, as a bank account rather, that is in their name. So where you've got savings over 16,000, you can combine that with income to meet the overall minimum income level. where you know, if someone is fortunate enough to have savings of, I believe it's £62,500 just sitting around, people can rely on that alone to meet the income requirement for a single applicant. So if you were applying for your civil partner to join you in the UK and you had, let's say, capital of £70,000, £70,000 that you had in a savings account in your name, and you'd held that consistently for 6 months, let's just say it was related to the sale of property or a similar asset, then a bank statement covering that full 6-month period would you know, serve to meet that requirement. So I mean, capital, when it comes to application logistics, it's always a good one to rely upon because the documentary requirements are really quite straightforward. It would just be that bank statement covering the 6 months and, you know, being no less than a month old on the date of application submission, and perhaps some ancillary documents to show where that money came from. The Home Office does want to understand, you know, if someone just gets a random lump sum into their bank account, sometimes I think that they can be concerned that that money might have been, you know, donated by a family member to facilitate the application and might not actually be retained by the applicants. So they just want something to understand where the money came from. So moving to the next slide, we just got a few examples to try to lend a little bit of colour to the information. I appreciate it's somewhat in a vacuum, so hopefully a little bit more detail here. Let's say an applicant's partner is based in Australia, but returning to the UK to work. So this was one of the questions within the chat. Hopefully this will help illustrate that. You've got the applicant, so let's say in this instance they're an Australian national for ease, a British national, the applicant's partner moved to Australia, fell in love with the Australian national, and the two of them decide they want to relocate back to the UK together. The applicant's partner has been working with the same employer for at least 5 years in Australia, earning a good gross salary there. Critically, the applicant's partner, i.e. the British national in this particular scenario, has a confirmed job offer in the UK to start within 8 weeks of their return with, again, a good annual salary. Therefore, the applicant's partner will meet both the current salary requirement and a future salary requirement to meet the financial requirement under category A. So category A being that income from salaried employment of the partner. So where you have this particular scenario, the requirement of 18,600 must be met in the country in which the applicants are based, i.e. Australia, and the partner, the British national in this instance, must be going back to the UK into a job that also commands a salary at 18,600. So because in this instance, they are currently earning that much and have been doing so for 5 years, they will be going back to the UK, and then within 3 months of their arrival, they will have a job that commands that same salary. They meet this requirement. Specific to one of the questions in the chat, let's say in this example A, we changed the facts a little bit. So it wasn't the British national that was working in Australia and coming back to a secure job offer. If it were the Australian national applicant themselves, unfortunately, the situation would not work. It has to be the British family member upon whom the application is based. It's that individual that must be working and coming back to a job in the UK. Example B, the applicant's partner is in the UK, recently had a baby, returning from maternity leave. So maternity leave can make things a little bit tricky. She has a contracted salary of, it's a good salary. It's in excess of the 18,600. Been with her current employer for at least 2 years. She's not been earning the required level for all of the last 6 months because she's been on mat leave, but that's okay because the period to be assessed could be the 6 months before she began her mat leave. And because she'd been working for them for 2 years and earning that good salary for that 2-year period, if we look at the 6 months before she went on mat leave, she will meet the minimum income requirement for her partner to come to the UK. So If, for example, the Home Office were to say, no, we're only going to consider the income you got on maternity leave, and that had dropped to quite a low amount for whatever reason, that's a very nuanced area depending on your tenure with your employer, etc., but they would effectively be discriminating against women having children. Obviously they cannot do that. The Equalities Act 2010 prohibits that, so there's a special allowance to look at the 6 months before the individual went on maternity leave. So in this instance, the minimum income requirement would be met.
Yeah, so I'll go into a bit more detail about applications from within the UK, and in particular the immigration status requirement for the individual who is applying. If you are already in the UK, you cannot be here with leave as a visitor, with leave granted for a period of 6 months or less, unless you are applying as a fiancé or a proposed civil partner. You cannot be on immigration bail, and you cannot be in breach of any immigration laws, which means you cannot be in the UK illegally without any valid leave. There are some exceptions to the above. So if the applicant has a genuine and subsisting parental relationship with a child who is under the age of 18, is already inside the UK, and is either a British citizen or has lived in the UK for at least the 7 years that immediately precede the application, and it would not be reasonable to expect the child to leave the UK, then you can apply if any of the above apply in your circumstances. Evidence of this would obviously need to be valid and recognised birth certificates, and you'd also need to prove that the relationship was genuine and subsisting, and that you had parental responsibility for the child. So you'd need to demonstrate that the child lived with you. Evidence such as letters from the doctor to prove that you have responsibility for the child according to their records and things like that can be used in this instance. The alternative is that the applicant has a genuine and subsisting relationship with a partner who is in the UK and is either British, settled in the UK, so with indefinite leave to remain, holds refugee or leave or humanitarian protection, or holds leave under Appendix EU, so they're an EU national. And there are insurmountable obstacles to family life continuing outside of the UK. The threshold for this one is much, much higher than for the first one, and this is generally a lot harder to prove. And visas granted under these exceptions will be placed on the 10-year route to settlement. So I'll be going into a bit more detail on this on the next slide. So in order to be eligible for settlement, the following requirements need to be met. The applicant must be in the UK with leave to remain as a partner. The applicant must have completed a period of continuous residence in the UK of at least 5 years, with leave to enter or remain as a partner. Now, this does not include the 6 months spent on a fiancé visa, and the individual must be the partner must be the same individual for the full 5-year qualifying period. So, if for whatever reason you apply to enter the UK on the basis of your relationship with one partner, and then that relationship breaks down, and then you apply to remain on your relationship with another partner, the continuous residency period would reset and you would need to complete an additional 5 years. The English language requirement for settlement is slightly higher than for the applications under Appendix FM. You will need to satisfy to at least level B1 on the CEFR. Applicants who are placed onto the 10-year route to settlement must meet all of the above requirements but complete a continuous qualifying period of 10 years. So if, for example, you apply on the basis of one of the exceptions I mentioned in the previous slide, then you will not be able to apply for indefinite leave to remain after 5 years, and instead will need to apply after 10 years. If you no longer meet certain eligibility requirements after initially being granted leave to remain or to enter under the 5-year route, then you will be switched onto the 10-year route, and then you will need to complete 10 years of residence before you can apply for indefinite leave to remain. And alternatively, if you're initially placed on the 10-year route to settlement, you can switch on to the 5-year route if you do meet the necessary criteria in the subsequent application. You are able to apply for a fee waiver if you're applying for permission to stay in the UK, which means that you'll not have to pay the visa application fees. And you may be eligible for this if you cannot afford to pay the fee because you don't have a place to live in the UK and you cannot afford one. You have a place to live but cannot afford essential living costs like food or heating. You have a very low income and paying the fee would harm your child's well-being. And you're also able to include your partner or children if they're applying to join or stay with you. Now, in this scenario, it would obviously only be children who would be able to apply to your dependents on the fee waiver. You will need to provide information about your financial situation, which will be verified by the Home Office. Examples of these can be bank statements, evidence of your household earnings and expenses, and you will need to provide them with a full and complete picture of your financial circumstances. Because they will be able to conduct their own checks and verify if, for example, you haven't provided any evidence of any bank accounts that you hold, they will know about this and they will request that evidence. You must apply for your visa within 28 days of the fee waiver being granted, otherwise you will need to make a new application. And applicants applying via a fee waiver will only be placed onto the 10-year route to settlement. So if you apply initially via a fee waiver and are placed onto the 10-year route to settlement, but then you are able to pay your application fees on the subsequent application and you meet all of the necessary criteria, you can switch onto the 5-year route.
There was a question, an excellent one, about the reference to European nationals, and the question was, can you explain why Appendix FM is for non-EU nationals only? An excellent question. There is a bit of nuance around that, so I'm going to hand over to Lauren to respond, please. Thank you, Lauren.
Hi Gemma, thank you.
Hi, thank you so much.
Sorry. The reason why this category is not specific to EU nationals is because if EU nationals are already in the UK and they're applied under the EU settlement scheme, so they hold pre-settled or settled status, then their family members would apply under Appendix EU instead of Appendix FM, and the requirements are similar, but not exact, so that would require more information there.
Super, thank you so much, Lauren. And yeah, exactly, just to reiterate, because of the B word, there are slightly different situations now for European nationals. The law has become more involved as a result of that, but really that the reference there is to the individual that the applicant would be joining in the UK. Where that individual is already in the UK and they are European, if they have status under Appendix EU, again, not terribly original naming there, that's Appendix European Union, there is a different route under which their family members can apply to come to the UK. It's quite an involved area that has reference to both family permits and then residence cards once here. Again, as I said, we'll be working closely with Caroline moving forward, so if there's appetite for a webinar specific to that subject matter, then absolutely we'd be happy to do that, but it is something that really deserves its whole independent webinar because it's a very nuanced area of the law.
Gemma, can I just butt in a second?
Please.
Caroline here. At what point will that change for EU nationals, so British citizens who have family members in Europe that want to come to the UK?
Yeah, no, absolutely, great question. So where the person that the applicant will be joining in the UK is British, most likely their family members will apply under Appendix FM, even if they're European. The nuance in relation to Appendix EU is where the person in the UK themselves, so the person that the applicant will be joining, is European. So if we think of it as two different cohorts. Cohort 1 are where the applicant will be joining a British national or somebody who is settled in the UK. Cohort 2 is where applicants will be joining a European national in the UK. So that's the distinction. It's the individual the person is joining, where they are British or settled in the UK. their applicant family member will be making an application under Appendix FM. Where the person that they are joining in the UK is European and has status under Appendix EU, most likely their family member will be making an application under Appendix EU. I would say it is really very nuanced, and it depends when the relationship began, whether that was pre or post the end of the transition period, i.e. the 31st December 2020. So it might just behove us to have a separate webinar on that just to address those very specific queries. There was a very good question. Would love to know, if my partner has permanent residence, does he count as settled? Yes, indeed. So if your partner has indefinite leave to remain, so let's say, for example, somebody was in the UK on a work permit, they work for 5 years and can apply for indefinite leave to remain. Once they have that status, they count as settled in the UK. So a family member could make an application under Appendix FM. Similarly, if somebody were in the UK as a student, then as a graduate, so we're in the UK for a continuous period of 10 years and applied for indefinite leave to remain on that basis, they would get indefinite leave to remain and then would be deemed as settled in the UK. So a family member could make an application under Appendix FM. Another good question, can the partner work in the UK once the visa is issued, and does the employment have to be at the 18,600 threshold? Yes, once the partner has their work permit, they can work in the UK without restriction to the resident labour market. They can work in an employed capacity, they can work in a self-employed capacity as they wish. Their employment doesn't have to be at the 18,600 threshold, just really, national minimum wage essentially. But as and when they've been here for that 2.5 years and are looking to extend, once they're doing that, if they wanted to rely on their income solely to meet the minimum income requirement moving forward, then their income would have to be at the 18,600 threshold. One question, when the cash savings come from sale of property, do they have to be held in the bank account for at least 6 months? I believe the answer to that is yes, because the savings, irrespective of how they are generated, whether it's sale of property or just hypothetically an inheritance or similar, the Home Office still want to see that bank statements evidencing 6 months of holding that capital. So if someone were to apply and the money had just come into their account, unfortunately, that would not facilitate the application.
Gemma, could I ask for clarification on quite an important point? In terms of the income requirement on first application, the 18,600 must be earned by the British partner and isn't a combined salary including the non-British partner, isn't that right?
That's absolutely right. Yes, that is indeed the case.
Yeah. And then following the further leave to remain will be based on combined income.
Yeah, exactly that. So where the initial application is being made from overseas, I know it seems arbitrary and it is rather unfair, but unfortunately the position from the Home Office is that where you are applying from overseas, only the income of the British national can be borne in mind. So, even if the applicant, let's hypothetically say they're Trinidadian, even if the Trinidadian applicant was commanding a really, really good salary, where they're making their first application from overseas, unfortunately, it is not something that the Home Office will consider. But once they're in the UK and making that application to extend, or if they're making their first application from within the UK, because perhaps they're here on a student visa, then their salary can be borne in mind. It's just that initial application from overseas where the focus from the UK authorities' perspective is on the income of the British national or settled partner.
Thank you.
Thank you. I'm very conscious of time, so I'm just having a quick look for any questions to which I can quickly respond. Oh, someone had a question about a list of cohabitation documents. So there isn't a sort of an exact list that the Home Office want to see, but the kind of thing they'd be looking for is joint bank statements, evidence of combined financial evidence is something they really like to see. utility bills in joint names, leases in joint names, property ownership documents, so title deeds, for example, in joint names. Those are all the kind of things that they like to see. I'm terribly sorry, guys. I'm conscious that we're at time, and I myself do have to jump for another meeting. The questions about Appendix EU and such, Caroline, if you're able to send them over to me, what I'll do is put together a couple of paragraphs which will hopefully clarify that for everyone, because I appreciate it is a really nuanced area.
And what we'll do, I've written all the questions down as well.
Brilliant, thank you.
What would be great is if we send them across, and then we can do like a fact sheet based on the questions that we've been asked.
That sounds great.
And then we can send that out to everybody. And in the meantime, any other questions you may have, do send them to me at my email, which I'll just put in now. And indeed, if you would like any other sort of more specific webinars, like with the EU, for example, then please do let me know. This is the first one that we have done, and with Fragomen, so we are very keen to get some feedback as well. And we'll send the recording and the slides after the session. I don't think there's anything else that I can say. And yeah, do join our Facebook group if affected by the rules or are navigating the process. It's a peer support, lived experience, private community where you can ask lots of questions. But thank you so much to Fragomen for your time this morning. We will be looking at doing another one at some point, but it will be on our website, and we will put it in our Facebook group as well, so you will have access to this recording.
Thank you everybody so much. I do apologise that we weren't able to get to all the questions, but exactly as Caroline said, what we'll do is put together an FAQ that tries to address as many of them as possible, specifically looking at the income requirement, because I wholeheartedly appreciate that's the most stress-inducing element, I think, and also addressing those nuances between the distinction of applicants coming under Appendix FM and Appendix EU.